And welcome to HIPAA Training with Accountable. This required training must be completed by any employee with access to protected health information. It shouldn't take too long to finish, but there is a quiz at the end, so be sure to pay close attention. First things first, what is HIPAA? HIPAA stands for the Health Insurance Portability and Accountability Act of 1996. Simply put, it's a federal law that was enacted on August 21st, 1996, to reform and modernize the flow of information within the healthcare system. The first main purpose of HIPAA is to enhance privacy and to provide the security for protected health information, or PHI. Another goal was to increase efficiency and effectiveness of the healthcare system overall. And lastly, HIPAA was designed to establish standards for accessing, storing, and transmitting medical data and ensuring the security and privacy of PHI. The next video will cover the privacy rule, which defines what is considered protected health information about an individual and specifies what restrictions are placed on who may use, disclose, or access that information. The security rule, on the other hand, refers to how this information must be safeguarded through a system of administrative, physical, and technical safeguards for electronic protected health information. We'll explain these three safeguards and more in the third video. The last video will cover the most recent additions to HIPAA. The HITECH Act and the Omnibus Rule have been passed to improve healthcare information technology, impose stronger regulations, and increase compliance with HIPAA by the required parties. This three-step video course is designed to help you understand all the basic elements of HIPAA. This was just a quick overview. We'll get into more detail in later sections. Good luck, and see you in the next video. In this video, we'll go through everything that you need to know about the first rule added to HIPAA, which was the privacy rule. This rule is a set of national standards designed to ensure protection of certain protected health information. The privacy rule gives each person rights to their protected health information and provides a framework of rules for who is authorized to view or share that information. A major goal of the privacy rule is to ensure that an individual's health information is adequately protected, while still allowing the necessary flow of health information required to promote high-quality health care. So you may be wondering who is covered by the privacy rule. HIPAA requires both covered entities and their business associates to comply with the privacy rule. A covered entity is any organization that is directly involved with the treatment, healthcare operations, or payment processors for healthcare services. On the other hand, business associates are vendors that work with covered entities to provide a service or function that requires them to use or disclose personal identifiable health information. Covered entities include health plans such as health insurers or HMOs, healthcare providers such as physicians and dentists, and healthcare clearinghouses. Business associates can be any person or organization that does not work for a covered entity but creates, receives, maintains, or transmits PHI on behalf of a covered entity. Common business associates include shredding companies, lawyers, medical transcription companies, and even accountants. All of these organizations have to safeguard PHI, or protected health information. Protected health information, PHI, is any individually identifiable health information that is sent or kept in any form, electronic, oral, or written, where the information is created or received by a healthcare provider, health plan, employer, or healthcare clearinghouse. This information might relate to the health or condition of an individual, the healthcare treatment that they are given, or the payment for any healthcare services. Any health information is considered PHI if there is a reasonable basis to believe that it can be used to identify an individual. Examples of individual identifiers include patient names, geography, such as street address or city, dates except years, like a birthday or admission date, and even telephone numbers. Uses and disclosures are another important element of the privacy rule. Under the privacy rule, covered entities and their business associates can only use protected health information for employment, application, examination, or analysis within their organization. There are only two situations where an organization is required to disclose PHI. First, to an individual or their personal representatives when they request access to their PHI. And second, to HHS for purposes of compliance investigation or review. The HIPAA privacy rule permits the use or disclosure without the patient's authorization for the following purposes: treatment, payment, and healthcare operations. Treatment involves providing, coordinating, or managing healthcare and related services. Payment includes billing and collection activities, determining plan eligibility or coverage, and managing claims. And last, healthcare operations refers to the administrative activities involved in running the business of a covered entity. Covered entities must get an individual's authorization for uses and disclosures of PHI for any purposes other than these treatment, payment, and healthcare operations. The authorization must be in writing, and the form must include certain elements required by HIPAA. The privacy rule requires covered entities to make reasonable efforts to use, disclose, or request PHI only to the minimum amount necessary to still accomplish the intended purpose of the use, disclosure, or request. HIPAA provides individuals with certain rights with respect to their PHI, including the right to access, review, and obtain copies of their PHI, the right to amend or have changes made to errors in their PHI, the right to request a list of disclosures of PHI by covered entities or business associates, and the right to request restrictions on the use or disclosure of PHI. Organizations are also required to comply with the administrative requirements of the privacy rule, including adopting policies and procedures that appropriately protect the privacy of PHI. Appointment of a privacy officer who will oversee and be responsible for the organization's privacy policies and procedures, workforce training on HIPAA compliance, and business associate agreements with any entity that you're either sharing health information with or receiving health information from. The Office of Civil Rights of HHS is charged with enforcing HIPAA and the privacy rule, and they can investigate covered entities and business associates, respond to complaints, and impose penalties for non-compliance. Entities and individuals may be subject to either civil or criminal penalties for violating the HIPAA regulations. Currently, civil penalties can range from $100 to $50,000 per violation, with caps off at $1.5 million for identical violations each year. And that's all for the privacy rule. But get ready, because next up is the security rule. The security rule. We've just discussed the HIPAA privacy rule, which protects the use and disclosure of PHI, regardless of the form in which it exists. But now we'll move on to the security rule. The security rule sets the security standards for the protection of electronic protected health information, ePHI, which is health information that is held or transmitted specifically in electronic form. The security rule is a set of regulations designed to ensure the confidentiality, integrity, and accessibility of electronic protected health information. This means protecting ePHI against unauthorized access, use, or disclosure, guarding against threats or hazards to the security or integrity of ePHI, and providing access to ePHI to authorized persons when required. The security rule, like the privacy rule, applies to all covered entities and business associates that transmit or store PHI electronically. The Department of Health and Human Services, HHS, recognizes that covered entities and business associates range from small providers to very large hospitals and health plans. Accordingly, the security rule is intended to be flexible enough to allow entities to analyze their own business needs and determine solutions to fit the nature of their business. The security rule is made up of 3 types of required standards that all covered entities and business associates must follow: the administrative safeguards, physical safeguards, and technical safeguards. The majority of the security rule is focused on the administrative safeguards, which refer to the administrative actions, policies, and procedures put into place to manage the development, implementation, and maintenance of an entity's security measures. The rule sets out specific administrative safeguard standards, the first of which is the security management process. This says that a covered entity must conduct regular and thorough HIPAA risk assessment to identify potential security vulnerabilities so that they are then able to implement necessary security measures to address those weaknesses. The second standard of security personnel is achieved through the appointment of a privacy officer who maintains responsibility for developing and implementing the organization's security policies, procedures, and training. The next is information access management, which focuses on restricting access to ePHI to only authorized personnel and to those people only when it is necessary to complete their job. The final administrative safeguard deals with workforce training and security awareness. Employees need to complete an annual HIPAA training, such as these videos, in addition to being trained in organization-specific security protocols and procedures, starting from the date of hire with regular updates as needed. Contingency plans also need to be implemented so that in the event of an emergency or natural disaster that could damage the system containing the EPHI, all personnel are aware of the correct next steps to take. Let's move on to physical safeguards. Physical safeguards are the procedures for protecting PHI within the electronic information systems, physical equipment, or buildings that it's stored in. These safeguards include facility access controls such as door locks and personnel badges that control who is able to enter the facilities that hold PHI or EPHI. When it comes to EPHI, any computer, tablet, or smartphone that can access EPHI needs to have proper protection and security so that unauthorized users cannot use that device to view the private information. This includes passwords and electronic encryption, as well as procedures for storing and disposing of these devices outside of the security facility. The last type of safeguard, technical safeguards, are equally as important to ensure that there's a low probability of a breach of PHI. The first element of this safeguard is implementing policies and procedures that limit access to EPHI to only those who are authorized. In addition to access controls, audit controls should be used via hardware or software to record and monitor system access and activity. This aspect is extremely important as it allows organizations to see exactly what information was accessed, who accessed it, and how long it was viewed, which is instrumental in mitigating damage in the event of a breach. Transmission security is also an important element to prevent unauthorized access of EPHI that is being transmitted electronically, especially over the internet or via email. Verifying user identification, typically through the use of passwords, PINs, digital signatures, or biometric mechanisms, are also an important element of technical safeguarding your EPHI. Organizations are required to implement reasonable and appropriate policies and procedures to comply with the security rule standards that we just outlined. All written security policies and procedures must be kept at least 6 years from their last effective date, and organizations must periodically review their policies to ensure continued compliance with the security rule. And that wraps up the security rule. Next up, the HITECH Act and the Omnibus Rule. HITECH and the Omnibus Rule. Now that we've introduced HIPAA and covered the privacy and security rules, we'll finish by talking about the most recent additions to HIPAA, the HITECH Act and the Omnibus Rule. In 2009, Congress passed the American Recovery and Reinvestment Act, which included, in part, the Health Information Technology for Economic and Clinical Health Act, or HITECH for short. HITECH aimed to streamline healthcare and reduce costs through healthcare information technology. HITECH also marked a significant expansion in the reach of HIPAA and imposed new regulations and requirements with respect to PHI. On January 26, 2013, the Health and Human Services Office of Civil Rights published the most recent rule addition to HIPAA, the Omnibus Rule, as a means of actually implementing the changes that were outlined in HITECH. Among changes made by the Omnibus Rule were the additional rights given to individuals with respect to their PHI, the expanded responsibility on business associates and subcontractors, the imposition of a new breach notification system, and the expanded enforcement and penalties. Through this expansion of individual rights, patients may now request to receive a copy of their electronic medical records. Patients may also restrict the disclosure of their PHI to health plans in situations where they pay for the services or treatments entirely out of pocket. The Omnibus Rule sets new limits on how information can and cannot be shared or disclosed for marketing and fundraising activities, and also prohibits the sale of PHI without an individual's authorization. One of the most significant changes that was brought about by the addition of the Omnibus Rule was that business associates were made directly liable under HIPAA. This means that business associates are accountable not only to the covered entities they work with, but also straight to the HHS for their compliance with the privacy and security rules. This change added the requirements for business associates to conduct workforce training, implement security policies and procedures, appoint a privacy officer, and report breaches, among other privacy and security rule requirements. The Omnibus Rule also extends liability to all the subcontractors of business associates, requiring them to protect and safeguard PHI to the same extent. In the event of a breach of unsecured PHI, covered entities and business associates are required to report that breach to all affected individuals as well as the Secretary of HHS, unless the covered entity or business associates are able to determine and prove that there is a low probability that the PHI has been compromised. To determine the probability of PHI having been compromised, covered entities and business associates must complete a thorough risk analysis, taking into account the nature and extent of the PHI that was involved, the person to whom the impermissible disclosure was made, whether the PHI was actually acquired or viewed, and the extent to which the risk to that PHI has been mitigated. The high-tech and omnibus rule now requires the HHS to impose harsher penalties for violations of the privacy and security rules. The omnibus rule introduced a tiered approach to imposing penalties depending on the organization's perceived level of knowledge of the violation. Each tier contains ranges in fine amount per violation based on the level of negligence, with a max of $1.5 million in fines for multiple violations of an identical provision in the calendar year. The Omnibus Rule also gave the State Attorney General the authority to enforce the HIPAA rules and impose civil and criminal penalties against covered entities and business associates. Covered entities must also review and revise their notice of privacy practices to reflect the high-tech and Omnibus Rule changes, including the new breach reporting requirements, changes related to disclosure of PHI to health plans, plus the marketing and sale of PHI. Congratulations!